there is possibility of settlement because both the parties are not inclined to reside with each other. Both are ready to give mutual consent divorce.
कब से अलग अलग रह रहे हैं आप लोग?
10 साल हो गए सर.
10 साल. So under that Muslim act there is no
provision.
There is no
For
concept
mutual
of divorce by mutual consent.
It is either by the personal law of Mohammedan law or by under special marriage act. Both the parties are directed to be present today. Both husband and wife are present in the court. There is possibility of settlement because both the parties are not inclined to reside with each other. Both are ready to give mutual consent divorce.
Okay, so we'll direct the family court. What's the family court ka?
Family court.
You can file a joint application there and कब से अलग अलग रह रहे हैं आप लोग?
10 साल हो गए सर.
10 साल. So
Also having a child of about
to waive the period of waiting of the 6 months का होता है. देखिए इसमें
provision section 28 and 27A
of
in special marriage.
This will be under which provision?
The
Muslim Vivah Vigatan Adhiniyam 1939 में.
Dissolution of Marriage Act 1939 under section 2 subsection 8.
My lord, but the petition
By mutual consent हो सकता है?
By mutual consent it can be done under the special marriage act.
Not under this.
Not under this.
prayer was rejected on the ground of the plaintiff has not prayed relief in respect of special marriage act. On that ground, the prayer petition was rejected. We come to the para number 20 of the improved judgment.
नहीं वो मुस्लिम होगा कि नहीं? ये 39 अंदर ही होगा. So under that Muslim act there is no
provision.
There is no concept of divorce by mutual consent.
It is either by the personal law of Mohammedan law or by under special marriage act.
अच्छा.
My lord, just come to the para number 20 of the improved judgment.
I think that is why this the talk of unified civil code.
Yes.
All personal laws are supposed to be made rational and equal. And that is the concept behind unified civil code. Because a lot of personal laws have a lot of arbitrariness,
Create difficulty.
inequality, irrationality. So that will be creased out. Those creases will be ironed out.
Yes, my lord. Everything is one uniform civil code.
Special Marriage Act में कहाँ है? Section
under section 28.
28 before the family court.
For that, joint application will be submitted before the family court. But my lord, the one very important.
Just a minute.
Presented to be before the state board.
I see you are waiting for the Okay, so we'll ask the family court. You file there. and we'll waive that waiting period of 6
My
months.
lord, just one prayer. Please come to the para number 20 of the trial court judgment.
Yes.
वर्तमान प्रकरण में याचिका
एक रुक जाइए. Para? हाँ, yes.
वर्तमान प्रकरण में याचिकाकर्ता द्वारा अपने अभिवचन में उभय पक्ष के बीच हुए संपन्न निकाह दिनांक 3/4/10 को विच्छेदित किए जाने एवं उससे संबंधित मेहर की राशि वापस दिलाए जाने मात्र का अनुतोष चाहा गया है, जबकि अभिलेख पर उपलब्ध साक्ष्य से उभय पक्ष के बीच दिनांक 19/3/10 को भाई उत्तर प्रदेश में मुस्लिम विधि के अनुसार विवाह को संपन्न होना तथा विशेष विवाह अधिनियम के तहत दिनांक 2/7/10 को विवाह प्रमाण पत्र जारी किया जाना प्रकट हुआ है। ऐसी स्थिति में दिनांक 3/10 को संपन्न हुए मुस्लिम विवाह एवं विशेष विवाह अधिनियम के तहत दिनांक 2/7/10 को जारी किया गया विवाह प्रमाण पत्र से संबंधित विवाह दिनांक 2/7/2010 के विच्छेद के संबंध में याचिकाकर्ता द्वारा अनुतोष नहीं चाहे जाने से याचिकाकर्ता को अनुतोष नहीं दिया जा सकता। While there is limited, some prayer has not been claimed before the trial court. On that ground, the petition was dismissed. Now, before this honorable court, this is the first appeal. Then, Order 41, Rule 33, there is a power of the appellate court to grant the relief, and also in the compromise decree in respect of Order 23, Rule 1 and subsequent provisions. Both are agreed for the divorce. And for 10 years they are living separately, and their future affected. If application will be presented before the family court, some more time are taken.
We'll direct for waiving of that 6 months waiting period. 6 months cooling period is there under 28(2).
Yes,
so that will say that we waive because immediately they are staying away from each other since almost 1 decade.
my lord, we think fit what is necessary for the.
कहाँ का है ये?
Riva.
रीवा का. Stay in Riva.
Yes, my lord.
Already. The present appeal assails the judgment and decree passed on so and so by so and so in so and so, whereby the petition for divorce preferred by the wife was rejected by the court, rejected by the family court. The wife is before this court assailing the aforesaid in this first appeal. The husband had appeared before this in person on why so?
20th of June 2023.
My lord, one small prayer. The divorce petition has already been submitted by the husband before the family court. Now the petition is pending before the family court.
So why to fight it out? If you can go by consent.
Directed to family court, take it in mutual consent and decide.
That is what we are doing. हस्बैंड ने फाइल कर दिया तो क्या उसको विड्रॉ करेंगे?
विड्रॉ करना पड़ेगा
सर, उसको विड्रॉ करना पड़ेगा क्योंकि वो म्यूचुअल कंसेंट के आधार पर नहीं है।
वो आपके ऊपर है, आप विड्रॉ करना चाहें कर सकते।
जी जी।
All right. And appeared before this court in person and had expressed his desire to stay away from his wife. Expressed his desire to part ways with his wife. Since he was staying away from his wife
Since more than 10 years.
about 10 years, with no hope and possibility of settlement. We'll stop next, but in view of the above, it is obvious that the wife as well as the husband both want the marriage to be annulled and stay away, to enable them to stay away from each other. Next. The parties have expressed their desire to invoke the provisions of Section 28 of the Special Marriage Act to obtain divorce by consent. Next para. It is also informed by, at this juncture, it is informed by the learned counsel for the husband.
Yes.
That the husband has recently filed a divorce petition in the family court at Rima,
Yes.
which is pending adjudication. The husband has also, next subparagraph, husband has also expressed his desire that if this court permits the husband to obtain divorce by consent, then he is ready and willing to withdraw his divorce petition. Next para. We of the above submissions and the consensus arrived at between the rival parties. This first appeal stands disposed of in the following direction. Number one, the parties shall jointly approach the family court at Rima under Section 28 of the Special Marriage Act 1954 by filing an appropriate application, along with an application for condoning the cooling period of 6 months. Number two, if the aforesaid direction is complied with within a period of 30 days from today, then the joint application filed under Section 28 of Special Marriage Act shall be considered and decided by the family court of competent jurisdiction. Competent jurisdiction by waiving the cooling period of 6 months, considering the fact that the rival parties are staying away from each other since nearly a decade with no possibility of settlement in the matter. The family court at Rima is expected to decide the matter as expeditiously as decide the divorce petition filed with consent as expeditiously as possible, preferably within a period of 1 month from its presentation.